My Lords, I rise to speak to Amendment 81 in my name, which is substantially the same as one that I tabled but withdrew at committee stage, and I am grateful for the support of my noble and learned friend Lord Garnier, the noble Lord Blunkett, and the noble Baroness Lady Burt of Solihull. We're dealing with a shame and a scandal. I'm not going to dwell on the nature of it because it's been well spelt out by the noble and learned Lord Brown of Eton under Hayward. So I shall just come to the substance of the amendment, because of the three tabled on this topic, it is the one that is most modest and most helpful, and intended to be most helpful, in fact, to the government. Unlike Amendment 80, just referred to by the noble and learned Lord Brown of Eton under Hayward, it does not concern those who are in prison serving an IPP, only those living in the community on licence, that is, those who have been released after the parole board has resolved that they do not represent a serious risk to public safety. At the moment, these persons are potentially subject to a lifelong licence, and they can be recalled to prison for a breach of the licence conditions at any point. The only way the licence can be terminated is for the individual to apply to the parole board for a licence review after the expiry of the qualifying period, currently set at 10 years. Now, the government have stated that they would wish those reviews in future to take place automatically, not requiring an application from the prisoner. And my noble friend Lord Wolfson of Tredegar said on the 21st of July in a written answer to the noble Lord Blunkett, from September this year, officials will refer automatically to the parole board the case of every offender serving the IPP sentence who has become eligible to apply for termination of his or her IPP licence. I take that as a definitive statement of government policy. Automatic referral. But yesterday, when I attended the meeting of the Justice Select Committee in the other place just referred to by the noble Lord Blunkett, and a question about this was put to Sonia Flynn, Chief Probation Officer, she did not reply using those words. She said something rather different. She said that from September the probation service had started proactively encouraging those who qualified to make an application. And she had no explanation when asked by a member of the committee why, of the 500 persons currently entitled to apply for their licence to be terminated, only 20 had applied. There's good reason why the probation service is not carrying out the policy in the terms set out by my noble friend, because close examination of the current legislation makes clear that the review can only be undertaken on the prisoner's application. The government cannot, therefore, make an automatic referral to the parole board without the prisoner's active collaboration. This amendment addresses that deficiency by amending the Crime Sentences Act 1997 to make an automatic referral to the parole board at the end of the qualifying period, and if the application is dismissed, annually thereafter. The referral does not depend on the acquiescence or collaboration of the prisoner, so it allows the government to do what they have said they want to do, and I hope it will command their support. What it does not do is prejudge in any way the decision of the parole board makes on that referral. That remains a matter for them. Noble lords may wonder why an offender who is entitled to a review at the end of the qualifying period should not have made one on his or her own initiative. What is the need for automaticity? But the simple truth is that many IPP prisoners out on licence, after that many years, simply don't want to re-engage voluntarily with a criminal justice system they believe has treated them so unfairly, even when proactively encouraged. It's the Home Office. We have a form for you to fill in. This is the answer to the question that was put to the Chief Probation Officer about why only 20 of the 500 had applied. So automaticity is a good and necessary thing. The government agree, and it would be very strange if the government held out against the substance of this amendment, given that it gives them the power, the statutory power, to carry out their own policy. But there is another part to the amendment. I referred earlier to the qualifying period after which a review of the licence can be applied for, or if this amendment were passed, would take place automatically. And that qualifying period is set by law at 10 years. The very last words of the amendment would have the effect of reducing the qualifying period to 5 years. For those IPP prisoners who received a short minimum term, the 10-year licence period is wholly disproportionate, and it can hardly be argued to be necessary for public protection, because, as I said earlier, under this amendment, the decision whether or not to terminate the licence remains with the parole board, and reducing the qualifying period to 5 years simply reduces the length of time after which an individual is entitled to apply to a review. These people will be out on licence with the approval of the parole board and will have shown themselves safe in the community for 5 years. The number of IPP prisoners recalled after 5 years out on licence is very small, and the latest data shows that no IPP prisoner committed a serious further offence 5 years or more post-release. So the risks to public safety in this essentially administrative change is zero. I very much hope my noble friend will accept the modest changes affected by this amendment. I hope that noble lords will bear in mind not only the plight of the prisoners, the offenders affected by this sentence, but also that of their families, who have stuck with them in many cases and struggled and fought for them, and whose lives as a family has been disrupted and damaged, and in some cases come close to destruction by the injustice that has been done and the impossibility, the practical impossibility, of recovering the life of a free citizen. I hope to hear encouragement and undertakings from my noble friend. If not, I give notice now that reluctantly I may wish to test the opinion of the House.